Hello students, my name is Sunita Sridharan. I am a lawyer and a patent agent. I am also the founder and the CEO of SKS Law Associates, which is a law practice handling patent work which is based in New Delhi. Today I am going to handle module number 28, which is relating to patent rights and the limited exceptions therein. The entire focus of this module and this session would be to look at what are the patent rights and what are the exceptions to the patent right. As you are aware, the patent owner is granted a patent right by the government of a country in which he has filed the patent application after due prosecution. This patent right gives him the right to exclude third parties from using his invention. This invention may be a product or it may be relating to a process. You are also aware from your previous modules that patent right is enshrined in Section 48 of the Patents Act. But you will also be aware that Section 48 is subject to the previous Section 47, and it says very clearly that subject to the exceptions in Section 47, the patent right is granted. In this presentation, I will touch very briefly on the patents, the patentability requirements, non-patentable subject matter, and the exceptions to patent right. The exceptions are experimental or scientific use exception, foreign vessels exception, public non-commercial use exception, regulatory use exception, prior use exception, exhaustion of patent rights exception. Now, to come back to the brief background on patent and its significance, you are aware that a patent right is owned by the patent owner, and a patent owner can be the inventor himself or any person to whom the inventor has assigned his rights in the invention. So, the patent owner can be a company also by way of an assignment. The patent owner can also be the heir of the inventor or the person who is assigning his rights, and this is by way of operation of law. For instance, in case a will has been written. The patent grants a right to the patentee for a period of 20 years. That is how it is in India and in most of the countries around the world. Now, in these 20 years, he has a right to exclude others from working the patented invention without his express permission. Now, you would have heard about PCT applications. In case of a PCT application, that is the Patent Cooperation Treaty, and applications filed thereunder, the patent term for a national phase application is the date on which the international application was filed. And in case of Paris Convention, it is from the date on the first priority. Now, just to touch briefly on the rights that the patent owner has under Section 48, it says the rights are territorial in nature. The rights are subject to exceptions laid out in Patents Act, especially Section 47. And in case where the invention is a product, the Section 48 very clearly states that the patentee of a product patent has the exclusive right to prevent unauthorized third parties from making, using, offering for sale, selling, or importing for those purposes the product into India. In case of process patents, the patentee can stop a third party from the act of using, offering for sale, selling, or importing for those purposes the product obtained directly by that process into India. Now, having looked at the rights, let's just quickly look at the significance before we go on to the exceptions and find out why those exceptions are significant too and why they have been enshrined into the law. The patent has certain significance. For instance, it is seen as an award to the inventor for inventing something and for contributing to the technological advancement of society, because every patent application which has been filed gets published in 18 months' time and comes into public domain for people to access, to study, to read and to build upon. However, for the entire term of patent, where as long as the patent is in force, a third party cannot use the invention. He can read about them, but he cannot use the invention commercially without the express permission of the patent holder. And as you know, this is for a period of 20 years. Now, what are the exceptions? We have looked at a number of exceptions when we started the session and we listed them out. Now, we shall go into each one of them very briefly. You can read about it in greater detail in the module, in the written module, and you can also read up on the different case laws as and when they come up in the courts or when you are going through the case laws or the various journals. But for the purposes of this presentation, we will try to understand what are these exceptions and why are they there and the significance that they have on the patent owner and the society at large. Now, to talk about the section 47 exception, which is very clearly enshrined in the section which deals with the rights of the patentee. It says that the use by government for own use is exempted. That means the government can use any machine, any process or any drugs or pharmaceutical or medicines which are patented or which are pending patent application. It can use them for the own use. That means the government cannot commercialize, but it can use for public non-commercial use. And these are enshrined in section 47(1), section 47(2) and in section 47(4). We also have a very interesting exception which very few countries in the world have, and this is known as the experimental or the research exception. Please do not confuse this with the Bolar exception, which is very different. That we shall deal with in a little while. The research or the experimental exception clearly states that if you are using the invention, the patented product, the patented process for any experimental work or for teaching or for use in a laboratory without any commercialization, then the patent owner cannot bring a charge of infringement. Therefore, it means that any of the universities, any research lab can use any of the patented invention which has been patented in India. You must remember that the Patent Act 1970 and the rules apply only to the territorial jurisdiction of India. So, if the patent has been registered in India, then the patent owner cannot bring an action of infringement where that particular patented invention is used in a university or is used by a research lab, even if the research lab belongs to a company which is otherwise commercially engaged in commercial activities. The section 47(3) is a research exemption which is crucial for R&D that is research and development, and can be used very effectively. And it is very surprising that very few people are aware of this provision. Unfortunately, this provision of section 47(3) is often confused with Bolar exemption, and therefore the confusion arises both amongst the people as well as with the courts during arguments in different cases, and this leads to major confusion.